Hey YouTube, in this video I wanted to go over some civil procedure questions and key terms in order to help you study for your midterm or final exam. What are the three things that you need in order to establish a lawsuit? And that is subject matter jurisdiction, personal jurisdiction, and venue. What is subject matter jurisdiction? It is the power of the court over the controversy without it any judgment that the court renders is void. The power of a court to hear controversies derives from the Constitution and various federal and state statutes. The lack of subject matter jurisdiction can be raised as a defense by anyone at any time during the suit. Concurrent jurisdiction means an action can be brought in either state or federal court. Exclusive jurisdiction means an action must be brought in either federal or state court. In diversity jurisdiction cases, federal courts have jurisdiction over controversies involving state law if there is a diversity of citizenship between the defendants and the plaintiffs, and the claim is likely to exceed $75,000. In order to establish diversity jurisdiction, no plaintiff can be from the same state as any defendant, and the claim must be likely to exceed $75,000. Corporations, however, are citizens of both their state incorporation and principal place of business. Some controversies are generally reserved for state resolution. For example, divorce cases are brought in state court. Supplemental jurisdiction provides jurisdiction over other claims that arise from the same set of operative facts as the principal claim asserted in federal court. Supplemental jurisdiction replaces the concepts of ancillary and pendent jurisdiction. Removal jurisdiction provides the defendant the right to remove any action from state court to federal court if the action could have otherwise been brought in federal court, unless the basis for removal is diversity jurisdiction, and in that case, the defendant cannot be from that state. Personal jurisdiction is the power of the court to bind the defendant to any judgment it renders. Personal jurisdiction is waivable and can be conferred by consent of the defendant. The defendant confers personal jurisdiction upon the court by failing to raise it in its first defensive move. Personal jurisdiction is obtained by establishing the defendant's minimum contacts within the jurisdiction such that the court's exercise of jurisdiction is reasonable. Entry of a product into the stream of commerce, however, is not a sufficient basis for the exercise of personal jurisdiction. General jurisdiction is when there are so many contacts, ties, and relations within the forum state that the defendant is essentially at home and can be sued by anyone for any reason. Service of process on an individual while voluntarily in the forum state satisfies the due process requirement. Specific jurisdiction is when the cause of action arises from the defendant's contacts, ties, and relations in the forum state. It must satisfy the minimum contacts test, which the elements are systematic and continuous activity, meaningful and purposeful activity, doesn't violate traditional notions of fair play and substantial justice, receive the benefits and protections of the forum state, and foreseeable being hailed into the forum state. In Rem jurisdiction is the exercise of jurisdiction over property when the property is the focus of the dispute. An adverse possession claim is a good example. Venue refers to the proper district in which to bring the action. The venue should be where a substantial part of the events giving rise to the cause of action occurred. It should be a convenient place to try the case based on the location of the witnesses, the evidence, etc. In federal court, the test for venue considers where the cause of action arose and where the defendant resides. A corporation, for example, resides wherever it has established the minimum contacts. In state court, the test for venue considers the location of the plaintiff, the location of the defendant, and the forum where the cause of action arose. Rule 882 is a short and plain statement of the claim showing that the pleader is entitled to relief. The complaint should contain statements of fact and not conclusions of law. In the complaint, you should state the facts in a clear and concise manner. Notice pleading. Notice pleading only requires that you put the other side on notice as to what happened. Establish a prima facie showing that there has been a violation of the law and your client's rights have been affected by that violation. Rule 12b-6 is a failure to state a claim upon which relief can be granted. A jury trial must be demanded pursuant to Rule 38. If you want a jury trial, you must demand it, or you waive your rights to have your action tried before a jury. All parties must be properly named, or the case can be dismissed for failure to join an indispensable party. A class action is where a large group of people have been injured as a result of common questions of law or fact, such that they can sue collectively to obtain relief. The named representative of the class must be capable of adequately representing the interest of all, and the named representative plaintiff's injury must fairly and typically represent the injury that has been suffered. When a stakeholder is holding funds or something to which there are multiple claims or possible claimants, the plaintiff may file an interpleader to have the court determine the rights of those claimants. An interpleader action provides the plaintiff with assurances that it will not be exposed to multiple liability. Damages are designed to make the plaintiff whole. Damage awards are designed to put the plaintiff in the position it would have been but for the defendant's actions. In addition to general and special damages, which are designed to compensate the plaintiff for its losses, punitive damages may be awarded in rare cases to punish the defendant for its wrongful behavior and to deter other people from similar action in the future. There are three types of injunctions. There are temporary restraining orders, preliminary injunctions, and permanent injunctions. Injunctions are either mandatory injunctions or prohibitory injunctions, which force a party to do something. A preliminary injunction may be issued after initial hearing of some sort where both parties have a chance to present information. A permanent injunction is issued only after a full hearing on the merits of the case and remains in force unless reversed on appeal. Injunctive relief is granted at the discretion of the court. Since injunctive relief is an equitable measure, it is granted or denied by a judge without the aid of a jury based on the five-part analysis. The five-part test that the court uses is 1. Adequate remedy at law. 2. Likelihood to succeed on the merits. 3. III. Immediate irreparable injury. 4. The balance of harms in favor of the injunction. And 5. Public policy considerations in favor of the injunction. Collateral estoppel means that the issues have been fairly and fully litigated and judgment is final. Res judicata means a claim has been fully and fairly litigated and the judgment is final. Stare decisis requires that any time a court has decided a case fully, fairly, and with finality between the same parties or someone in privity with the parties, then, consistent with the principles of Collateral Estoppel and Res Judicata, the relitigation of those issues by the same parties or someone in privity with those parties is therefore precluded. The Due Process Clause of the Constitution requires a defendant to receive notice and an opportunity to be heard prior to the award of any judgment. Rule 4 provides the mechanics of effectuating service of process, which is consistent with the requirements of the Due Process Clause. The service of process standard requires that notice be reasonably calculated under the circumstances to apprise the defendant as to what is going on. After proper service, a defendant has various options. First, he or she can choose not to contest the facts and allow a default judgment to issue pursuant to Rule 55, or he or she can respond to the complaint by either filing a motion to dismiss or filing an answer. Rule 12b-6 tests the sufficiency of the complaint and asks the court to dismiss the action for failing to state a cause of action upon which relief can be granted. Rule 12g encourages the consolidation of various defenses in a single motion to dismiss. The defendant must answer the complaint in a clear and concise manner, either admitting or denying the allegation in the complaint. Rule 8c requires affirmative defenses to be pled by the defendant or they are waived. The most common affirmative defenses are Laches, Estoppel, Statute of Limitations, Res Judicata, and Collateral Estoppel. Statute of Limitations is the applicable time period to bring a cause of action. Laches means the plaintiff has delayed asserting his right, which has caused prejudice to the other side. Estoppel means that a position has been taken earlier upon which the opposition has relied, and therefore you are bound to that earlier position. Rule 11 describes the good faith requirement of all attorneys who sign pleadings. In every pleading, the attorney certifies to the court that he has read it, understands it, made an investigation, is based on existing law, or a good faith belief in reversal of existing law that is not interposed for any improper purpose, such as delay or harassment, and believes that it has a meritorious pleading. Rule 15, pleadings can be amended pursuant to Rule 15, and leave to amend should be freely given. Counterclaims and cross-claims are filed pursuant to Rule 13 and are claims for relief filed by defendants. Counterclaims are claims asserted by the defendant as part of the response to the complaint. Counterclaims are either compulsory or permissive depending on whether they arise from the same set of operative facts as the principal claim, which are called compulsory, or from a different set of facts as a principal claim, which are called permissive. Compulsory counterclaims arise from the same common nucleus of operative facts as the principal claim. There is no need for a separate basis for jurisdiction. Permissive counterclaims arise from a different set of facts as the principal claim and therefore do need a separate basis for jurisdiction. Discovery is a formal process in a civil suit where information is exchanged between parties, and the exchange must be relevant to the suit if it helps prove or disprove the suit. The scope of discovery is found in Rule 26, which says you may obtain information from the other side which is relevant to the lawsuit or which could lead to relevant information that is not otherwise privileged. Rule 33. Interrogatories are written questions submitted to a party which must be answered under oath. These are limited to parties to the suit. Requests for production of documents and things pursuant to Rule 34 require a party to produce relevant documents or things upon proper request. Requests for a physical or mental exam under Rule 35 can be filed if the physical or mental condition of a party is an issue in the case but is limited to a party or agent of a party. Pursuant to Rule 36, you can ask for requests for admissions, which require a party to admit or deny certain statements of fact. Attorneys examine and cross-examine the witness whose testimony is preserved by audio, video, or stenographically. Rule 30 applies to parties and witnesses. If Rule 45, which is the command to attend and testify and produce documents, is used with Rule 30, then a non-party can be deposed and required to bring documents and things with them to the deposition. Sanctions under Rule 37 are imposed because of a failure to comply with discovery requests. In the Insurance Corp of Ireland case, the court sanctioned the defendant for failing to cooperate in discovery and precluded that party from contesting certain issues in the case. Rule 37 gives teeth to the requirement that parties should comply with all proper discovery requests. Summary judgment tests the sufficiency of the pleadings taken as a whole to see if there are any material facts in dispute. Summary judgment is when there are no material facts in dispute that rise to a triable level, and the judge determines how the law resolves the case. Summary judgment tests the sufficiency of all the pleadings. Juries determine questions of fact. Judges determine questions of law. Material fact is a fact of consequence to the lawsuit. In a civil case, it is the plaintiff's burden to show both liability and damages. There are three standards of proof: preponderance of the evidence, clear and convincing evidence, and beyond a reasonable doubt. Preponderance of the evidence is the general civil standard that requires the claimant to tip the scale ever so slightly in its favor. All you need to show it is that it's more likely true than not true, 51% to 49%. Clear and convincing evidence standard is the civil standard that is reasonably equivalent to the criminal standard, which is beyond a reasonable doubt. Rule 51 deals with instructions to the jury. You must object to offensive instructions given at trial in order to preserve the issue for appeal. Rule 48 deals with the size and unanimity of the jury. Rule 48 requires a unanimous jury in reaching a verdict unless the parties agree otherwise. A motion to dismiss tests the sufficiency of the complaint. Motions for a judgment as a matter of law test whether a reasonable jury, based on the evidence submitted, could find for the other side. Motions for summary judgment test the sufficiency of the pleadings taken as a whole to determine if there are material facts in dispute that rise to a triable level. These are the three testing motions: Rule 12, motion to dismiss; Rule 50, judgment as a matter of law; Rule 56, motion for summary judgment. Choice of law issues arise particularly when a case is being tried in federal court. A federal court resolving issues of federal law uses federal law to resolve those issues. A federal court always uses federal rules of civil procedure if the rule is on point. Diversity suits are the most common source of conflict law problems because they involve citizens from two different states, and therefore, at a minimum, two states' laws should be reviewed. The outcome determinative test requires that in a diversity suit, The results should be the same as in federal court as they would be in the state court hearing the same matter. Exception. The only time the outcome determinative test can be violated in resolving diversity suits is when there is a federal rule of civil procedure directly on point, or when an important federal right is at stake, such as the right to a jury trial. A federal court sitting in diversity is nothing more than an extension of the state court system which would hear the matter. Therefore, state substantive law will be used to resolve that controversy, and the result should be the same as it would be in state court hearing the same matter. Well, I hope you enjoyed the video and got some value out of it. If you did like it, please leave a comment or hit the like button. Thank you.